This is the first Judge Ben C. Green Distinguished Lecture in Law. I'm the Dean of the Law School, Gary Simpson, and I want to begin by introducing the guest speaker, but first I'd like to give a special welcome to Ro Green. Her father, the late Judge Green, graduated this law school in the class of 1930 and had the distinction of being the first graduate of the school to be appointed to the federal bench. President Kennedy appointed him for the Northern District of Ohio, and he served for 20 years. Like her father, Ro is a member of the Society of Benchers, the group which honors alumni and friends of the law school for their contributions to the legal profession, the community, and the school. Since establishing the visiting professorship in her father's name in 1989, the family of Judge Green has enriched the experience of the law school by bringing top scholars to our campus, including the speaker today. The visiting professorship was converted to a chaired professorship in 1999, and Kevin McMonigal of our faculty has held that chair since it was created. Ro has been a very strong supporter of the school. During the Leading the Way in Legal Education campaign, she gave the school the largest outright gift it has ever received. The renovated library, the Ben C. Green Law Library, is named in her father's honor as a result. I'd also mention in the community, her philanthropic impulse is very evident anywhere in the Cleveland area, and I think we're really honored to have someone supporting the school of the quality of Ro. The speaker today, Professor Laurie Andrews, as I mentioned, was the Ben C. Green visiting professor in 2000. At that time, she spoke on cloning. Her talk today will be called Biobanking and Bioethics when Genetics Research Hits the Courts. She's the director of the Institute for Science, Law, and Technology at the Chicago-Kent College of Law at the Illinois Institute of Technology. She's also associate vice president of that law school. For many years, she's been an advisor on biomedical law to Congress, foreign governments, and various federal agencies. She served as a consultant to the science ministers of 12 countries on the issues of embryo stem cells, gene patents, and DNA banking. She was the chair of the Federal Advisory Committee dealing with the legal, ethical, and social implications of the Human Genome Project. She was recently named an Honorary Fellow of the American College of Legal Medicine for distinguished achievement in the field of legal medicine. She not only has written numerous articles, 10 nonfiction books, but she actually has published a novel. As I was saying to Ro, my father repeatedly says to me, "You write articles, how about writing a novel?" Well, it's something I don't have the talent for, but she obviously does, and she wrote a thriller about genetics, and in May of this year, she's going to publish the sequel called The Silent Assassin. Before I turn over the podium to her, I just want to mention at the end of her talk, she will take questions from the audience. A couple of people will be handing around microphones, so wait for the microphone before you ask any questions. And before we start here, I'd like to invite her up and have her at least present her with a token of our appreciation for her coming here. It should be under here. Thank you very much for coming.
Well, I'm positively thrilled to be back at Case Western. I was so honored when Max Mellman called me those years ago and suggested that I had been chosen as the Judge Ben Green visiting lecturer. And I had a fabulous time, fabulous faculty, fabulous students, and it was wonderful to be able to spend time with Ro during that period. And, you know, I'm such a big fan of so many of the faculty members here that it was a great, great experience, and I'm delighted to be back. What else would drag me out on a snowstorm, not only on the O'Hare front, but at the Cleveland airport and so forth. And I'm going to talk about some research into genetics today. And what prompted my interest was that when I was growing up, I read a newspaper article that said the chemicals in the body was worth 89 cents. Well, today, the price tags on human body parts have gotten to be much greater. A human egg can be worth tens of thousands of dollars, and the value of a particularly interesting gene can be millions. There's one gene that's worth $1.8 billion a year to the pharmaceutical company that owns it. And so the body's now a source of commerce, the egg donation ads. This is, believe it or not, a Nobel laureate, Kary Mullis, and he got the idea that he wanted to use celebrity DNA in jewelry and market that. So he would have a watch. He's trying to do a watch with Abe Lincoln's DNA and so forth in it. But, not only has it been commercialized in that sort of extreme setting, but also in terms of research itself. Different body parts have become used more and more in the pharmaceutical and biotech industry. In 1998, researchers discovered that leftover embryos from in vitro clinics could be used to create embryo stem cell lines, and the idea is that you would use different lines, say, to repair an ailing heart by creating a stem cell line of heart tissue. But mainly, tissue has great value in research. And I want to start with the story of a researcher, Susan Malkin, who's at the National Institute on Aging. And she wanted to find out what cures might be developed for Alzheimer's disease by looking at what proteins were active during the disease. And so she convinced healthy volunteers, as well as Alzheimer's patients, to undergo spinal taps so spinal fluid could be collected, and then to try a particular drug and give another spinal tap to see what proteins were active. And then she took a temporary job at the Food and Drug Administration. And when she came back to NIH, she went to the freezer to get her samples to continue her research. And her boss told her that the freezer had malfunctioned and they had been lost. So all those people who had put effort. But that seemed a little odd to her. And so she started asking more and more questions. And it turned out that her boss had actually given 3,000 tissue samples to a pharmaceutical company. And he personally got $285,000 in consulting fees and a $311,000 travel budget, which took him to Hawaii a few times. And it was particularly interesting because federal employees are supposed to fill out forms when they have consulting arrangements. And he had been asked if he had any outside consulting arrangements, and he replied that he had none, even though he was working with Pfizer and had this ongoing relationship with them. And then when people started asking questions at NIH, he said this was a mere paperwork thing, that he'd forgotten to file a few forms, and they found he'd not disclosed 140 separate activities with outside companies, kind of a lot to forget. So tissue is valuable. You can patent genes out of tissue. It's important, but it's important ethically and legally for us to think about what the rules should be. And I'm going to ask three types of questions today. What's our obligation to the people who provide the tissue, people who go through these painful spinal taps or give up DNA? What obligation should scientists like Trey Sunderland have? And, what is happening with the law of gene patents? Now, the first one about ethical obligations to the people whose tissue we use, I'm going to talk about in terms of Albert Einstein's brain and Mick Jagger's sperm. There actually was a run on a sperm bank in London thought to have Mick Jagger's sperm. Now, imagine the next generation in Liverpool with those thin hips and big lips and so forth, if all the women got their wish and had his baby. At the same time, Albert Einstein, when he died, the pathologist at the hospital, without any advance consent from Einstein, kept his brain even though Einstein had said he didn't want to be subject to research, he wanted to be cremated, the pathologist decided to keep it for research purposes. And it's not uncommon for our tissue to actually be used without our consent. And I don't know if you realize it, but for this end of the room of students, everybody born in the United States since the 1960s has had a test at birth, a genetic test that public health departments do based on a little heel prick of blood from the baby. And many states save those samples. So you can go to a place like Texas, and if you wanted to do DNA testing on people who have been born anywhere in the past 40 years, you can do that. In addition, hospitals sometimes keep your pathology samples from, you go get a routine cholesterol test, you get a biopsy, and so forth. And in fact, there are actually over 160 million Americans who have their tissue on file someplace, many without realizing it. And hospitals have begun to think, okay, we have a capital resource here. And they've started making deals with biotech companies. I had this amazing experience. I talked to the College of American Pathology, the National Pathologist meeting, and one pathologist said to me, sometimes I go down to do an autopsy, and the hospital's already sold the bones, the tendons, and all this. And so I can't really tell what cause of death is because we use the bones as like a geography to say, well, what's supposed to be next to there or this. And it's an amazing change. Lots of places have deals in place with a particular biotech company, sold off 140 million human samples that way. But think about it. Think about Einstein, who wanted to be cremated. People's religious wishes might be violated by what's done with their tissue. In addition, what's done with a person's tissue in the DNA area has implications for relatives. One of the things they tested Einstein's brain for was a genetic propensity to aneurysm. But if they found he had that propensity, then blood relatives might be in the position of losing their health insurance or employment because of this genetic risk. In addition, there are concerns about doctors viewing their patients as potential treasure troves, looking for different types of lucrative tissue and so forth. And I want to talk briefly about a case a lot of people are familiar with in the law community. It's taught now in property and other areas. And this is the case of John Moore. He he had hairy cell leukemia. He had his spleen removed. There were smiles of recognition and the student end. And what happened, it's an interesting story of the power of lawyers. He actually had been cured, but his doctor led him to believe he was still sick. And for 7 years, his doctor asked him to keep flying back from Seattle to Los Angeles, and the doctor did a lot of things that weren't common in treatment of hairy cell leukemia. He took sperm and bone marrow and so forth, because before the surgery had even taken place, he realized that this man produced a valuable chemical in his blood, and he actually filed a patent on it. And so finally John Moore said to his doctor, listen, I can't afford to just keep flying back from Seattle for these things. Surely I can give blood someplace in Seattle and you can test it. And the doctor said, no, you have to fly back, but I'll pay for your airline ticket and put you up at the Beverly Wilshire Hotel, this fancy hotel. And so he went immediately, walked into just a young lawyer's office and said, I think I might have had malpractice committed on me because, your doctor doesn't usually offer you all these goodies. And this young lawyer went on an electronic database system and to look for publications of the doctor. And sure enough, there was a publication with a footnote that said, I've patented a cell line out of this 47-year-old man from Seattle. And the doctor, I'm sure they don't do this now, was dumb enough to name it after him, John Moore, the Mo cell line, so they knew it was exactly his thing. And John Moore went to court and said, you've sort of stolen my property. I feel like I've been raped. You didn't tell me. I kept thinking I was sick. And he said, quote, I was harvested. So he sued. It was so unusual, the court threw it out. who has the property right in their body and so forth. What do you mean? The doctor should have informed. And it went up to the Court of Appeals, and they basically said, listen, this is California. If Bela Lugosi has a right to his image, commercial rights to his image, shouldn't a person have a right over their genetic code, which is so much more personal than a photograph? And they pointed out that the Uniform Anatomical Gift Act allows people to choose what's done with their tissue after they die, and so shouldn't you have a right to make that choice while you're still alive? So they, at the Court of Appeals, would have given this property right to John Moore to control what was done with his tissue. But it went up to the California Supreme Court, and they ruled that the patient didn't have a property right in his tissue, but he had valid claims against the doctor for violating his right of informed consent. If you're going to be commercialized, your doctor should tell you, and now there's an AMA rule to that effect as well. But one reason that they gave for not giving the patient a property right was what many scientists had said, that you don't have the laboratory in your home to be able to do anything with your DNA, and so you shouldn't have a property right in your tissue and in your DNA. But if I discovered oil in my backyard, even if I didn't have a refinery at my disposal, I would still assume I could sell it. And it's been very interesting to see what hospitals have done now, because even hospitals who don't have the equipment to do the research are selling off tissue samples. So they're in exactly the same position as John Moore, but the patient was not allowed that right. So he warned about harvesting. I've been involved in some cases where that appears to have happened in some way. These are two children who have a disease called Canavan Disease, which is more likely among Ashkenazi Jewish families. And their parents, other parents, two nonprofit foundations decided they would find a geneticist to try to identify the gene so that testing could be done to see who was a carrier of the gene for Canavan disease and and to test pregnancies to see if the fetus was affected, much as is done with Tay-Sachs. And all these people were active in the Tay-Sachs community. There's a group, the National Tay-Sachs and Allied Diseases Association, and they offered free or low-cost Tay-Sachs screenings in schools and synagogues. And so the Greenbergs said, we want that to happen with Canavan disease. So for 13 years they gave money and tissue samples to a doctor to try to find the gene. And they picked this doctor because he'd been active in these free Tay-Sachs screening programs. Well, what happened was the doctor discovered the gene, his hospital patented it. And even though there were doctors willing to do free screening, the patent holder shut those programs down. They said, we want a royalty every time the test is used. And we had a situation where the Canavan Foundation wanted to give money for the study of this disease. The American Neurological Association people wanted to do the research, but they were unwilling to do so because of the cloud of the patent hanging over. And so in a pro bono case we brought causes of action again for things like conversion. This is my property, for breach of informed consent, like in the Moore case. And the court held that the only claim that it would recognize was unjust enrichment, that somehow the hospital and the doctor shouldn't be able to benefit entirely from the tissue resources and money that the patients had put up, and ultimately the case was settled. Well, at least in that case, the Greenberg case, people knew what was being done with their tissue. It was being used to find a gene for Canavan disease. But in other instances, your tissue is used, you don't even know what is being done. And I've been following the case of the Havasupai, who are a Native American group, small, 650 people. They live in the bottom of the Grand Canyon. You can only get there by horse or by helicopters that run 2 days a week. And researchers came down there and said, listen, you have a high incidence of diabetes among the Havasupai, and we can look for the gene, we can do educational programs for you, we can help you. And so members of the Havasupai gave their tissue for diabetes research. The researcher did not disclose that she already had an NIH grant funded to do schizophrenia research on that group. And it turned out that she arranged for someone to go into the tribal health office after hours and get medical records on, whether people were schizophrenic or not. And through an incredible quirk, which was that one of their members actually enrolled as a student at Arizona State University, came out of the Grand Canyon, and someone said, "Oh, why don't you come listen to this dissertation defense?" And it turned out it was someone talking about the inbreeding research, the schizophrenia research, and research that conflicted with the religious origin stories of the Havasupai. So this woman found out about it, one of the Havasupai members, and they brought litigation, which is currently going on, about things like fraud or lack of informed consent for things being done that they didn't consent to. And so it's very interesting because they're a pretty powerless group, and very remote. But even very powerful people are finding themselves in this situation. This is James Ellis, who's a vice president of AT&T, lawyer, and he was told he had prostate cancer and was going to die unless he had surgery. And at that time, his doctor at WashU, Dr. William Catalona, said to him, "I'm doing research on prostate cancer, and would it be okay if I kept some of your tissue to do this research?" And Dr. Catalona had been asking people that since the 1980s and had collected a large amount of tissue samples and had actually created some interesting PSA tests, all these things that were able to predict prostate cancer. And James Ellis said, "Listen, I have enough on my mind at the moment. You've just told me I'm going to die. I can't think about research." And his doctor said, "Well, look at the form. It says you can change your mind at any time. It's for prostate cancer research. It's for me, who you trust." And so he signed it. But then what happened was Washington University realized it could make money selling the tissue samples to biotech companies as opposed to having Dr. Catalona do cancer research on it, which is what they promised the patients. And that bothered Dr. Catalona, and he changed institutions after all these years, and he moved to Northwestern in Chicago. And he asked his patients, he said in a letter, you could stay with your care at Case, you could come, at WashU, you could come to Northwestern, it's your choice, and you can decide what you want done with your tissue samples. And 6,000 patients said, "We want them to go with you. You're the cancer researcher we trust." And when he tried to get them, WashU went to court to sue that it was their property and not that doctor's or the patient's. So that led to another pro bono case that I got involved with a bit. And an interesting ruling, because here again the patient said, "That's my property. You violated your contract where you said I could withdraw at any time. It didn't say you get to own my tissue. I specifically agreed to research by this one doctor on prostate cancer. I didn't agree for it to be sold for, say, baldness research or other things like that." And many of the patients came forward, like James Ellis, and said, "Listen, I've got sons. I got involved in this research because I want to cure prostate cancer." Interestingly, what the court said was the existence of the informed consent forms is, quote, inconsequential. It doesn't matter what we as a research institution, told you. We can just not abide by it. Really interesting to me because it makes me want to go rent a car in Missouri, the state where this is, because basically, what it's saying is you don't have to abide by the agreement of the terms in which you're giving someone else the right to use your property. And yet we have things like the Nuremberg Code talking about research being absolutely, the informed consent being absolutely essential. So we've got tissue being used without our permission. We've got things like virtually every biologist has worked on these cells from an African-American woman in the late 1950s. And at that time, perhaps it was more common to do things without asking informed consent of the families and so forth. But when in the 90s her husband found out that, you can order up these cells from his wife through a catalog, he said, as far as them selling my wife's cells without my knowledge and making a profit, I don't like that at all. They're exploiting us both. And of course the family found out about it because, in part, researchers wanted to come back to them and test all the other family members and get all their tissue. Religious considerations play in. The Southern Baptists have a religious opposition to gene patents. But there's also a real question about, in this DNA era, what sort of control should you have on your tissue once it leaves your body? Actually, when President Bill Clinton was in London, his Secret Service people picked up every glass he left behind so that his DNA could not be tested. I think by that time, it's a little too late since there's that blue dress and that, but, they've had these attempts to get, DNA from, the royal princes and so forth. And if you think about it, what if you're, coming out of law school, you interview for a job, I take your Pepsi bottle when you leave and run your DNA and see if it's going to cost me a lot of money as your employer because you have a genetic predisposition increasing the risk of later disease. It becomes a crucial issue to have some control over what's done with our tissue. And I think of, for example, Neil Armstrong's barber was asked to take a follicle of his hair for a collector who wanted to do DNA and other testing. But what if Bill Gates' barber took a follicle of his hair and cloned him and sued him for child support? If you don't have a property right in your tissue, what are the ways that you protect against such an outrageous act? So, that brings me to the sort of second topic about scientists and the companies, the people actually doing the research. I was fascinated when a woman went into the British Patent Office and tried to patent herself. And she said, quote, "It's taken 30 years of hard labor to discover and invent myself, and I now wish to protect that invention." But in part, she was making fun of or raising issues with the gene sequence patents that are really the patent of people. And the British Patent Office said it's not really worth patenting something unless you make a lot of money from it. But she was underscoring the fact that there is a lot of commercialization in this area. And people have found that their DNA has been patented without their knowledge or consent. And it's interesting because much of this stems from a 1980 Supreme Court decision, the Chakrabarti decision, which allowed a patent on a genetically engineered bacteria, in the words of the court. So a bacteria that was supposed to be able to eat up oil spills. So it was something new. It was a life form, a bacteria, but it was it was engineered in a way that it had new properties that did not occur in nature. And so when the Human Genome Project was proposed to spend $3 billion worth of taxpayers' money to sequence all of our genes, the actual geneticists around the country who were doing it never expected to have intellectual property rights in the sequences they found. If you read the scientific literature at that time, what they said was, sure, we'll be able to get a patent on something genetically engineered that's new, but it would be terrible if you could have IP rights to the sequence itself, because then people would stop sharing tissue samples. They'd all want to be the one to discover the gene. Science would be less open. And in fact, that is what has happened. I have a friend, John Shestak, who is a movie producer, Air Force One and Firewall. Now he's doing Dan in Real Life with Steve Carell. And his middle son there was diagnosed with autism. And so John took the money he made in movies and went to elite universities and said, I will give you this money to search for a gene for autism. And at every university they said, we don't have enough tissue samples because you need a large number. Maybe they would have 30 tissue samples from people with autism or 50. And Jonathan said, well, why don't you share? And then you could find the gene. And, each one of them said, no, because we want to be the one to find the gene and patent it. And so what he ended up doing is creating this nonprofit, dummy, realizing that, and having a father who was the former president of the American Bar Association, Jerry Shesta, realized that the people with autism outnumbered the researchers 60,000 to 1, said, I'm just going to create this nonprofit bank, and we're going to ask the families to give to us instead of the universities, and we'll let it available to any researcher who goes through the university, gets an institutional review board approval, and that's what he's done to move autism research along. So what are people looking for when they get these tissue samples? This is the genetic code of life, and a very small typo in it can create a medical problem, and they're searching in the sequence for a misprint, a typo that creates a greater likelihood of having a genetic disease. Here is the typo that leads to sickle cell anemia. With Huntington's disease, there's a repeat of CAG numerous times in the Huntington's disease gene. But rather than being an invention, this genetic sequence is actually a product of nature. And so in that way, genes aren't like drugs. We patent drugs. We allow those patents. But it's very different. With drugs, there's a lot of private funding. With genes, there's substantial public funding. In 1 year alone, $1.8 billion of our taxpayer money went into gene research in genomics. The discovery of the breast cancer BRCA1 gene was funded with $5 million from the NIH, again, taxpayer money, and yet then individual companies patent these genes. So that's a difference from drugs, which we allow patents for. Interestingly, another difference is that with genes, you don't have that really expensive clinical trial period. A lot of what we see about why patents are necessary with drugs is that you have to go into human research trials, you have to then apply to the FDA. We've seen some estimates as much as $820 million to do those trials. That is not required in genetics for diagnosis. Once I learn the sequence, once I have that typo, I can the next day start testing people. And the FDA does not require that to go through any sort of human trials. In fact, as soon as the hemochromatosis gene was discovered, people began to test, and then what happened was somebody patented it, and 30% of the laboratories who had been previously doing it stopped, in part because they were asking for a $250,000 upfront fee and then a fee per test. So tech transfer is different in this area, and so forth. In addition, with drugs, I can invent around it. I can do something that improves it in some way, makes it time release or longer lasting, or how it uses alternative chemicals to get to the same biological pathway. But with genes, there are no alternatives. If I own the breast cancer gene, I can stop you from doing research. The holder of the breast cancer gene has stopped research at Penn and Yale on the gene. I can charge whatever I want for a genetic test. They charge $3,000. And one of the things that really troubles me is that learning your genome will be a great thing for pharmacogenomics. You can find out which drugs work on you. So some drugs only work on 3 out of 10 people for whom they're prescribed, and so you might be one of the unlucky 7 who takes it for a few months and then has to switch and so forth. Well, GlaxoSmithKline, which has an asthma inhaler, Flovent, has actually filed a patent application on the sequence that tells whether that drug works on you or not. And they've said for the 20 years of the patent, they are not going to allow that test to be used. They're not going to offer it themselves, or they're not going to let anybody else offer it. And so you can do that under patent law. You can prevent someone from using the sequence, but yet imagine how upset physicians, patients are, because the 7 for whom it's not going to work will keep paying to buy that drug and switching around, might have bad effects, and so forth. So it's a really interesting question. In Europe, you have to work your patent, actually use the invention, make it available. That's not true in the United States. And you also have the possibility, this is the patent on the breast cancer, BRCA1 gene, we're getting to the possibility, in fact, I think I have a little chip in my bag that actually is a small chip marketed by Affymetrix in which you could test 15,000 of your genes, half your genome. But the cost of this test alone, the BRCA1 breast cancer test, is $3,000. So if I have to pay that for every one of the tests on that chip, it becomes unaffordable. And in fact, we've seen some implications of that. 1 in 4 laboratories had to abandon a clinical test they developed because of a patent, and half had stopped developing tests. So these are some of the problems that have led the medical groups, the American College of Medical Genetics, the American Society of Human Genetics, the College of American Pathology, to say genes are products of nature, they shouldn't be patented, they have bad implications for health care. The World Medical Association considers genes to be the mankind's common heritage. So it's very interesting. We'll probably see some action in the courts about this because there's a very strong 150 years worth of precedent saying you're not supposed to be able to patent laws of nature or products of nature because we want scientists to have this freely available as the building blocks for what research is done. And what's happened is that we find that 1 out of every 5 medical scientists in one survey delayed publication of their results in order to protect a patent. And there have now been some surveys suggesting that a recent 2006 survey about students in the life sciences, who are finding that they can't have access to basic information they need in order to learn to work in a particular area. And I think really interesting is that, science is about hypothesis generation and testing and replication where others replicate your work. But 28% of the people with patents on, 28% of the life scientists said they've been unable to replicate results in a study because they were not allowed to have access to the sequence. It's even come into the criminal cases because the federal government gave $10 million for the development of a forensic DNA test of the type you see on CSI, but the developer of it was keeping secret the genetic sequences that the test looked at. And so no one could see if the test was effective or not. And finally, 3 courts threw it out and said, we're not going to allow this test to be used because you can't have, other scientists besides the commercial ones who are selling this test, haven't been allowed the chance to double check to see if this test actually works, is effective, is accurate. So I think that we're seeing some interesting changes. The Chicago Tribune published a major editorial asking Congress to liberate gene data. There have been Wall Street Journal and New York Times editorials in this area. The extremely pro-business Forbes magazine has criticized the Patent Office for granting overly sweeping patents. And I talked a little at a faculty talk today about how patents used to be sought on things like a mousetrap, and now we see very broad patents on things like the idea of trapping mice and then being able to charge anybody royalty no matter what way they caught a rodent. And in part it stemmed from a recent head of the Patent Office who actually had T-shirts that said, this is the Patent Office, not the Rejection Office. So there's a willingness to grant patents in areas where we previously did not have them, and it's far from the idea of encouraging innovation, which was the initial idea. And the absurdity of this new patent mentality came home to me when I read legal advice from a New York law firm that athletes should patent their moves, so that if Michael Jordan had patented a particular style of dunking, no one else would be able to use it. And so in looking at this, I've found some interesting patents. There's actually, you're only supposed to be able to patent things that are novel, non-obvious, and useful. And someone, for years, when babies were born, people put the little footprint of, put the baby's foot in ink and put it on the birth certificate. Well, that isn't novel or non-obvious. So someone actually holds a patent on putting the baby's butt in ink. And so this is the patent itself, which has like a work of art. A 7-year-old got a patent on a method for swinging out a swing by pulling down the sides. Again, that doesn't seem so novel or non-obvious. And then someone actually got a patent on the comb over. So if you comb your hair in that way, you are violating the patent law. So I started out with Trey Sunderland, the researcher at NIH who'd had sold off basically tissue samples to a pharmaceutical company. He then was investigated, and there was a congressional hearing about it last June. Ironically, at the same day my novel Sequence came out, which is in part about a government employee who tries to, personally gain from a tissue bank. So it was pretty crazy. And I must say, I wouldn't have been novel writing if it weren't for having such a luxury of opportunity. When I was here at Case, I actually sat in on a fiction writing course, which was totally amazing because in part it was a group of like 19-year-old engineers with baseball caps on backwards who were too embarrassed to look at me since I was like their mother's age. And so I went after like the third class, and the assignment I think was to write 2 short stories for the semester, and they had a very famous visiting professor who was teaching it, and I said, listen, I can't do it, these guys don't even look at me, and plus I'm used to law where you write hundreds and hundreds of pages. I want to write a whole book this semester, forget this 2 short stories. And he looked at me and said, well, Lori, if you stay in this class, I guarantee you I'll knock $100,000 off your advance by having you write a more literary novel, which was very funny. So I stayed. I loved the idea of walking across from law school to the little yellow, adorable English department building. And by the end of the semester, all these guys were like my buddies. I mean, I had a computer hacker in what I was writing then, and at the last day of class, one of these young students gave me a disk. He said, this allows you to hack into any government entity. So it was a really, really fun experience. I didn't use that though. So, what happened with Trey Sunderland is that he actually was charged under a federal statute of conflict of interest, which applies to government employees, and is on 2 years probation and doing 400 hours of community service, so not a big sentence on it. And in fact, one of the research participants, a retired lawyer, is upset that he got away with just a slap on the wrist for, derailing basically tissue that had been given for the study of Alzheimer's, and that lawyer is now trying to get it, figure out where his sample went and get it back if NIH has it now. So he got, he got, brought to court for his criminal activities. Yet in all those other cases I've talked about, how the suit by the Greenbergs, Dr. Catalona, there hasn't been any statutory or other mechanism to hold researchers accountable. And I really think that so much of genetics research is based on, trust and, getting people to give up tissue because they really feel close to the researcher and want to do something altruistic for other people with those diseases. So using resources of the public, substantial amount of public funding, genes have been discovered and patented. And although copyright law has a fair use exception, patent law does not, and so some researchers have been stopped. And just last Friday, Congressman Xavier Becerra from California and Congressman David Weldon, a physician from Florida, introduced a bill to ban the patenting of genes, which in part is what's at heart with some of the tissue thefts and so forth, trying to find genes. And so I think maybe those of us in the Midwest should weigh in on this issue. And so if you've got comments or are interested in it, just email me and let me know what your thoughts are. So anyway, thank you so much for the opportunity to be here again, and I very much enjoyed having the chance to talk to you. And I'm open for questions. Max. Max is my hero, and now he's going to say something that will just totally destroy what I've said.
No, actually, I'm going to say something that if I were a law professor, I would know better than to ask this question, because I think it's a foolish question. But if we follow your suggestion and say that you can't patent things. Do the patent holders have a property right that then they have to be compensated?
Yeah, and so this bill, dealing with your exact question, is a prospective one. Since there is an issue of to undo the previous patents, would it be an unfair governmental taking because they already have a property interest through the patent? Now, there has been some talk about this in Congress, and there's at least an argument that since you weren't supposed to be able to patent genes in the first place, if you follow the logic that they are products of nature, that instead of having to pay out to these people, you can basically say you've already been compensated millions of dollars for this. So I think there's an argument that you could apply it retrospectively. Congress has chosen not to do so, and so that probably would have to be litigated. Because in litigation, if the Supreme Court said these were products of nature, they shouldn't be patented, then there's not a just compensation issue with applying it retrospectively. Another thing that could be done is the head of the patent office could re-examine even previous patents. And in another administration, that happened with the head of the patent office re-examining computer patents that were just given to frivolously in a way, and it did not raise any just compensation issues when he deleted, some of the claims that had been previously granted. Yeah.
In this talk, are you exclusively talking about the human genome and human genes, or all genetic sequencing and patents on, animal or plant genes?
Yeah. My focus has been on human genes because of the healthcare impacts, because I think there are individual rights issues, bodily integrity issues, but to the extent that we share, much of our sequence, with over 90% with chimps and so forth, it's hard to figure, it's hard to write a legal policy that doesn't, at some level, have an implication of having access to the ATCGs and that. It's always made me feel more humble and, and sort of put things in perspective that a lily has more genes than I do. When I read that, I thought, well, this is, it's good to keep in mind. You don't get too big-headed then. Feel free to ask about anything. I write about reproductive technologies. I'm
not sure I understand exactly. I really don't think I understand exactly what the status is of patenting human genes.
Okay.
But let me ask this question. Do you think it's possible to patent a mutated gene?
Well, there are two types of patents now. One is a patent on, well, there's several types, but one is, say, a patent on a whole gene sequence of a gene. But people have also patented just the mutations, like in the Greenberg case, the short part of the gene where you can test to determine whether something has gone wrong with that particular gene. Mutations and genes have been patented. Now, you raise an interesting question, is like, what if I created a really cool artificial gene that did something like, made a souped-up insulin that was good for the public? Now, in looking at this bill, what it would say is that the sequence has to be available. The ATCGs have to be unpatentable so everybody can work with that alphabet. But if I do the souped-up insulin gene by creating a sequence that is novel, I can patent the product that it creates almost like you patent the drug, this souped-up insulin. So in that sense, you would still have the incentive to invent.
I was just looking at the comment from USA Today,
Oops.
and we've gone an hour without hearing about Anna Nicole Smith. Do you have any comment?
Oh, I talked about it at my lunch. That's so. Next week I'm speaking at the American Association of Forensic Scientists, and I learned this past week that there's only 400 board-certified forensic pathologists in the country, and I swear 399 are working on the Anna Nicole Smith case. Yeah. Is someone back there? I think?
In view of your opinion that genes should not be patented, if that were the case, would that not hamper the economic incentive for discovery of new genes? And if so, would that not sort of put the kibosh on the development of new drugs and various tests? Mm-hmm. There has to be an economic incentive to develop this stuff.
Well, I mean, that's, there has to be an incentive, but geneticists were looking for genes before they ever thought they could have commercial rights, because you can get, unlike the newest, coolest widget, I can get a Nobel Prize, I can get tenure, I can get professional publications. And so there was absolutely no suggestion that this incentive of the patent law, we were already paying them to do it under the Human Genome Project. We were, they were already willing to do it without that incentive. And one of the tragedies of the Greenberg case, the Canavan case, was many other geneticists would have looked for that gene without patenting it. And so had they known he was going to do it, they would have just chosen another geneticist. And the fact that all the major scientific genetic organizations, the Association of Molecular Pathology, all those guys say it shouldn't be patentable. They're more interested in having it widely available so they can take it to the next step of developing test kits, of developing gene therapies. But if you bottle it up at the sequence stage, and I also think it might have made sense, 10, 15 years ago when it's hard to find a gene, but the fact that Craig Venter had third graders sequence DNA, and that a lot of it really is done by the machine itself. I mean, if you go into any of those big gene sequencing companies, you see, amazingly, I was in one that had like 30 sequencers and 3 cleaning ladies. And, it's done by robotics, and then they compare it by homology to what genes do they know have been discovered in the rat. And so, I don't know, give the patent to the machine then, But, yeah.
Can I ask a question on stem cell?
Sure.
Right.
Has anything.
Recently, it's been said that.
Mm-hmm.
Recently, they've said that you can have a choice of stem cell from adults, or you need it from a fetus. And I have a friend who's on the National Board of MS, and he said it's a lie. You need it from a fetus in order to do the research. Yet I tend to hope to believe it's the other way around. What is the truth?
Okay. Well, it's very interesting because why do we want stem cells? Stem cells are important because they can grow into any type of cell in the body. And so many scientists prefer to work with embryo stem cells because at that stage they are what's called totipotent. They can make any other type of cell. Now, there's a big gap because we don't know how to persuade them necessarily to become neurons or heart cells or so forth. Once you start using other things, tissue from people who are older, say my bone marrow, and try to do stem cell research, there's more of a chance that it's going along a particular path. And so oftentimes those type of adult stem cells are talked about as pluripotent. They can make many things, but they might not be able to make all the cell lines. I think there's a lot that can be done with both.
What about them from the umbilical cord? Is that just as good as the fetus?
Well, part of it is that, some scientists don't think it's quite as good, but there really is an enormous amount that can be done at any of those stages. And in fact, there was just a recent scientific report about using amniotic fluid, not just the cord blood, And so, and I've got to say that people, there was a big, $3 billion effort in California that was, Prop 71 on the ballot there to put money into stem cell research. And their idea is that you would then create an embryo that creates stem cells that would then be personalized to you. And, but the cost of those sort of things are huge. And so other researchers people like embryonic, like cloning your own embryo and then taking the stem cells because they feel the body would be less likely to reject it. But other geneticists are working on changes to the surface of a cell to make your body less likely to reject it. So there are other scientific avenues going on right now. Sorry, you had a question.
Oh, I was just thinking about organ donation.
Mm-hmm.
And are you a proponent? Do you think that that's okay? Or do you wonder what they're going to do with our bodies?
Very interesting. I think it's a good idea to do organ donation. You might have followed those scandals in New Jersey, all the indictments this past summer of commercial interests that had funeral homes and mortuaries and crematoriums give bodies and then misrepresented the state of health of the people who are involved. So there are some issues. And I did have a tissue bank come to me and say, when we ask people to give the gift of life, a kidney, should we also tell them that we're selling the bones to a biotech company? And they said, we're afraid people won't give the kidney then if they know we're making money off the bones. But the whole idea of informed consent is you tell people things that are material that will be important to them. So, if that's going to influence their decision, you should actually tell them. So no, I mean, I didn't mean to suggest that everybody is, disreputable and so forth, but that, we should think more about it because people really do have strong feelings about what should be done with their tissue even outside their body. Thanks. Okay.
I just wondered how much of the human genome has already been either patented or patents have been filed on it?
Yeah, 20%. So 1 in 5 genes is already owned by someone. So anyway, thank you so much.